Good morning. The five bench judgment. S. Abdul Nazir, B. R. Gawai, A. S. Bopanna, V. Ramasubramanian J. and B. V. Nagaratna. This five bench Supreme Court AR 2023 Supreme Court 330 Neeraj Datta versus State of New Delhi. Judgment dated 15/12/2022. Therein they have decided that if the complainant is no more and illegal demand and acceptance not proved, but the Supreme Court has given some guidelines that it may be inferred, the court may infer about demand and acceptance. So only because there is no demand, the government servant is not entitled for acquittal. So that is a ratio recently given. But here what had actually happened, this judgment is section 7, 13(1)(d), 13(2), 20 and the Evidence Act section 3, section 4 and also other provisions were deeply discussed. And if you want to go through the judgment, it is better to understand and revive your memorable knowledge about Indian Evidence Act, because the judge, Junior Most Judge B. V. Nagaratna seems to have written an article about Evidence Act. That's what I could understand. And they have also discussed about the other judgments of which were referred. So finally they held that that is important. They have also discussed about resgency. What is actually resgency? So that it is my duty to draw your attention on that discussion. Resgency, a fact, includes a state of things or events as well as the mental state, intention or animus. The fact in law evidence includes the factum probandum, principal fact to be proved, and the factum probans, the evidentiary fact from which the principal fact follows immediately or by inference. On the other hand, the expression fact in issue means the matter which are in dispute or which form subject of the investigation. They say then they have also discussed about what is direct evidence, what is original evidence, and section 59. Then they also said what is hearsay. Section 60 of the Evidence Act was also discussed. Hearsay is not defined under the Evidence Act. It is nevertheless in constant use in the courts. However, hearsay evidence is inadmissible to prove a fact which is deposed to on hearsay, but it does not necessarily preclude evidence as to statement having been made upon which certain action was taken or certain results followed, such as evidence of an informant of the crime. So this is what they have also discussed about 61, 62 of the Evidence Act. And finally, they have held that when the direct evidence of the complainant or primary evidence is unavailable owing to his death or for any other reason, the position of law when a complainant or prosecution witness stand hostile is also discussed, and observation made above would accordingly apply in light of 154 evidence. In view of the opposite, we hold that there is no conflict between the judgments. So lot of favorable, unfavorable discussions are there. You have to go through every paragraph of the judgment if you want to conduct Prevention of Corruption Act cases. Best wishes.